Hello, everyone. My name's Karen Boyd. I graduated from Berkeley Law in 1996. I'm a longtime alumni board member, and I'm currently the chair of the Silicon Valley Regional Engagement Alumni Chapter, which is the Silicon Valley REACH is our acronym. And while people are joining the webinar, I will discuss a couple of administrative matters. First of all, Silicon Valley REACH and other regional chapters are scheduling both in-person and virtual events. Some are educational, like this one. Others are just for fun, like last week we did a Stanford dish walk and then had pastries to counteract the exercise we all got. So a link to the schedule of alumni events should be going into the chat now. So hopefully you'll be able to see that. All right, yes, that is there. As the chat is going to be disabled for people attending the webinar. So as you have questions or comments on Professor Chacón's lecture, you can put those in the Q&A feature of the webinar, and Professor Chacón will be addressing questions at the end of her lecture. You can upvote questions by clicking on the thumbs up button, so that'll float questions up to the top of that Q&A. Let's see, other administration. The CLE sign-in form and supporting materials will be posted in the chat. So you can fill out the CLE form to get credit for today's program. That registration form will stay open for a couple of weeks, and then people who have registered will receive a certificate of attendance a couple weeks after that. Okay. So let me see where we are on participants. Great. So with those administrative matters out of the way, we are delighted to be, the Silicon Valley chapter is delighted to be hosting this virtual lecture from Trump to Biden, Immigration Law 1 year into the new administration with Professor Jennifer Chacón. Professor Chacón joined the faculty of Berkeley Law this past fall. And if you want to talk to somebody about UC Law schools, she is definitely your person. She has taught at almost all of them before Berkeley. She taught at Davis and Irvine and UCLA. She focuses on immigration issues and is the co-author of the textbook Immigration Law and Social Justice. She's authored and co-authored dozens of articles, essays, book chapters, and I could go on and tell you lots more, but I don't want to eat into her, Professor Chacón's lecture time, so let me turn it over to her now. Thank you so much.
Thank you, Karen. It's really nice to be here, albeit virtually. I think we're all pretty used to that by now, but it's a real honor and privilege to be able to join with you all today to discuss this topic. I wanted to start with a sort of caveat, I suppose, about what I'm going to be doing in this talk. I think for people who are in the trenches and in the weeds in immigration law, nothing I'm going to say is going to be particularly novel or exciting, although I'm happy to, in the Q&A, engage in questions on topics arcane or of general interest. But I just wanted to sort of flag that at the outset. What I'm trying to do here in this presentation is to look at some of the big policies that have, some of which have dominated the headline, some of which have had a sort of a lesser starring role, but trying to figure out sort of what the immigration landscape looks like now that we're well into the Biden administration. And the reason I think that topic is interesting, of general interest, and not just to people who are in the weeds and in the trenches in the immigration law world, is because obviously immigration is a highly politically salient issue. So people care very much about this issue, even when they know very little about it, and they have very, very strong opinions, regardless of what their level of knowledge might be, which makes my job always fun and interesting. But I think that's one of the reasons that this topic is of such great interest. And I think that certainly in his campaign rhetoric, President Trump made immigration law a very, very salient issue for voters on the national scene, right? The idea that he had certain defined ideas, exclusionary ideas about immigration policy was was one of his big draws to many of the people who voted for him. And immigration law was a theme that he returned to and hit upon repeatedly, not only obviously in his campaign, but also as president. So the border wall, the ban on travelers from several predominantly Muslim countries, the sort of hit to refugee admissions, the migrant protection protocol that kept people in Mexico. I could go on, right? There were many, many ways in which his administration was focused on immigration issues, and that was not at all surprising given the way that he ran for president. He made it quite clear that that was his goal. One thing that is perhaps more surprising or might be surprising to some is that although he sort of said that his aim and concern was always with unauthorized migration and that he had no problem with legal migration, many of the policies that were taken both kind of full front and center, but also under the surface of his administration, took broad aim at pathways of lawful immigration. So the numbers of people who were immigrating through legal channels throughout the Trump administration really came down. And I think that's one of the sort of untold stories for those not in the weeds and in the trenches about what happened during the Trump administration presidency, which is it was a broadside pushback on immigration, whether that be lawful or unlawful, whether that be authorized or unauthorized. And so that I think is an important sort of caveat, part of the story that I'm telling today. Obviously, President Biden ran on a different sort of platform, talked about pushing back on some of the more draconian features of Trump administration immigration policy. But it was also pretty clear that Biden was not the most progressive candidate in the Democratic field on issues of immigration law. So Senator Warren certainly ran to the left of him on immigration issues. Julian Castro certainly ran to the left of him on immigration issues. And ultimately, Bernie Sanders did as well. And so he was definitely the centrist candidate, I think, for the Democratic Party on immigration issues. He seemed clearly committed to pushing back on certain features of Trump administration policy, but it was quite clear, I think, to anyone who was in the weeds on immigration issues that President Biden was unlikely to be the champion for radical imagining of immigration policy, and he hasn't been. So he's fulfilled his billing in this regard. What I wanted to do was just walk through some of the big policy choices that were made by the Trump administration and look at sort of what's happened to those policy choices in the early stages of the Biden administration. And what we'll see are stories of both continuity and discontinuity. I want to share my screen here, and I want to make sure I'm sharing the right screen here. But I think it should be this one. I will leave it to my technical advisors to let me know if we're not seeing slides, but hopefully you are seeing the slides. And what I wanted to do was talk about issues of immigration policy that affect that kind of most heavily implicate the border. So here I'm talking about the so-called Migrant Protection Protocol, or the Remain in Mexico program, initiated by Trump and retained by Biden. Title 42 policies, those are public health initiatives that have affected migration management at the border, and the issue of refugees, overseas refugee admissions, as well as asylum processing in the US. And then I wanted to talk about interior enforcement choices. And by this, I mean immigration policing, identifying people for removal, detaining people in immigration detention centers in the country, and also certain forms of protection, particularly temporary protected status and deferred action for childhood arrivals, where we've seen some differences. And I think big picture, I will say that we've seen more differences and more clear differences between Trump and Biden with regard to the second category of immigration policy. So when we're dealing with interior immigration policies, there I think we see some pretty clear distinctions, and those distinctions may be likely to grow. At the border, we've seen a lot of continuity, which I think is interesting. And there's continuity in the interior sphere as well, and there's discontinuity in the border sphere. I don't want to oversimplify, but I do think it's worth noting that there's been a great deal of continuity in the border region and around border policies, and maybe less so when it comes to interior enforcement choices. So we might puzzle out what that what the implications are of that, what that means. So let me start with MPP, or so the official name of the program is the Migrant Protection Protocol, or MPP, but critics call it the Remain in Mexico program, because that's what it is, right? This was a program that was rolled out at the very end of 2018 and implemented in early 2019 by the Trump administration. And under this program, non-Mexican non-citizens who are arriving at the border and requesting asylum are given notices to appear, but required to, so they have a hearing date that's given to them, at least theoretically, but they're required to wait in Mexico until that hearing date, and then they can cross in for purposes of the hearing, but then they have to return to Mexico. And you can see the picture on the slide, which is a picture of a migrant camp that springs up in, it's partly in the wake of these choices, right? Because these are non-Mexican nationals, so they do not have a home in Mexico that they can go home to, and they can't go home to their actual homes because they're claiming asylum, which means that by definition, they fear persecution in their country of origin on account of specific enumerated characteristics. So the option then it becomes to wait across the border in Mexico. And so you had the growth of a series of encampments on the Mexico side of the US-Mexico border filled with non-Mexican nationals, largely, but not entirely, Central Americans. And so that was the sort of the impact of the program. President Biden campaigned, the campaign rhetoric that President Biden used suggested that this was one of the things that he was interested in discontinuing. But it is still in place. And the story of why is somewhat complicated, but interesting. So first of all, the administration did not move immediately to dismantle MPP. They moved kind of in an orderly way through, and some would say a painfully slow way through the administrative process until in June of 2021, Department of Homeland Security Secretary Mayorkas issued a memo terminating the MPP program and saying, here are all the reasons it doesn't work, here are all the reasons it's bad. It's a bad policy choice, and so I'm terminating the program. And bear in mind, of course, that US law actually creates a pathway for people to claim asylum. And so historically, when people arrive at the border, various choices are made about how to handle those individuals who are coming to the border to seek asylum, but sometimes they're detained pending their proceedings, sometimes they're released and paroled into the interior pending their proceeding, but usually they haven't been routinely sent back. And in fact, that was a very unusual choice. So Mayorkas said it's an unusual choice and not a good one. And so we're not going to do it anymore. And states sued. So Texas and Missouri sued and said the administration had not done the necessary work under the Administrative Procedures Act to rescind this program, and that the rescission of MPP was unlawful under the immigration laws. And that's an interesting argument, the latter, given that no administration prior to Trump had ever used MPP and the law hasn't changed. So it seems like something of a stretch to say that the law clearly requires administrations to do this. But that is part of the argument. And the other part of the argument is that procedurally the rescission was flawed. And a federal district court judge in Texas granted judgment for Texas and Missouri in these cases, and ordered the administration to re-implement MPP and to renegotiate with Mexico in good faith in order to re-implement the program. And that raises all kinds of interesting questions that we can talk about in Q&A about foreign policy power of executives and when courts defer and when they don't. But this is clearly an instance where the court did not defer. And so the Biden administration re-engaged with Mexico in negotiations about continuing the MPP program. In October of 2021, DHS issued a new memo trying to terminate MPP again and saying, we've restudied the issue, we've gone back and re-explored some of the concerns that the states have about this, and we still find that the program should be rescinded. But to date, the court has sort of treated that memo as a mere sort of reiteration of the previous memo, and litigation in that case continues with the Supreme Court scheduled to hear arguments in this case in April. So MPP remains in place and part of an interesting process of litigation that hopefully we can talk more about. And I think I included the Solicitor General's brief to the Supreme Court on this interesting issue. Another issue, and one that in some ways superseded MPP, was the Title 42 order barring admissions, largely at the southern border. Title 42 contains the public health statutes, and Section 265 of Title 42 authorizes the Center for Disease Control and Prevention to prohibit the introduction into the United States of, quote, persons and property, if doing so is, quote, necessary to avert serious danger of introducing a communicable disease into the United States. So it will not surprise you to hear that the administration used the COVID pandemic as the basis for ordering sort of a shutdown of admissions of many categories of people at the border on public health grounds. So that began in April of 2020, and in some ways it supplants and replaces MPP as the biggest tool of migration management at the southern border, because everybody is just being turned away. So this isn't a situation where you're being issued a notice to appear for a court date for a court hearing at a later time, which sometimes it certainly was supposed to happen under MPP. But this is a case where you're just being told you can't enter public health, the end. So you get a wide scale a refusal of admission, wide scale repudiation of people who are coming to the border. I think the estimate that I heard this morning was 1.7 million people have been turned away at the border under Title 42. The Biden administration has kept that policy in place as well. So this was another policy that he campaigned against, but then got into office, and I think was concerned about the potential difficulties that would arise if it were taken away, and people who have been rejected and turned back repeatedly for really months and years now, that this would lead to a high volume of people trying to return once the order was lifted. And so we've seen reluctance on the part of the administration to lift it. We have seen them try to create certain exceptions to Title 42, for example, in the case of unaccompanied minor children, and more recently, interestingly, for Ukrainians. But I think these sorts of exceptions highlight, first of all, the difficulty of labeling this as a public health initiative, especially alongside the fact that millions of people are still entering at ports of entry through other means, right? So it doesn't work as a public health story, particularly once you start adding particular kinds of exceptions to it. And nevertheless, I should say, again, in litigation, a federal district court judge in Texas, this time Judge Mark Pittman, found the exceptions for unaccompanied minors to be unlawful. So here again, you see the strategy of Republican-led states intervening when against Biden's efforts to liberalize immigration efforts at the border. We see the same thing in the border wall scenario, right? Trump was building a border wall. Biden, when he got into office, said, I'm not interested in that project, but we've seen Republican-led states intervening in litigation, saying the wall has to continue, the funding for this has to continue. The Biden administration has not properly considered the environmental consequences of stopping the border wall construction, and otherwise just pushing back on the legitimacy of efforts to change policies. So those are Title 42, MPP, border wall. Then there's the sort of refugee story. When we talk about refugees, there are sort of two different categories of people. And the picture I have here should be familiar because there was widespread coverage of the way that Haitian refugees who are arriving at the southern border, at the US-Mexico border, were treated or greeted by Border Patrol agents in the United States. And this is one image of that confrontation. And that was, of course, not under Trump, but under Biden, right? So there, again, the Biden administration had campaigned on a pledge to radically sort of reimagine immigration policy, moving it away from the inhumane policies of the Trump era. And I think these sets of images sort of highlighted the extent to which this isn't really always a Republican or Democratic story, but we have a fairly repressive and exclusionary immigration system that spans party. And this is an example of how that can happen. When we think about refugees, there are sort of two different categories that we think about. One is people who are overseas, abroad, not in the United States and not near it, who meet the statutory definition of a refugee. And for those individuals, there's a statutory provision that lets the president say, this is how many refugees we will take from overseas. And the Trump administration set that number lower and lower every year. And the final year of the Trump administration set that number at 15,000 overseas refugees for 2021. And this is historically significantly lower than what previous administrations, whether Republican or Democrat, had admitted. And it came at a time when, of course, there was massive need for refugee protections in a variety of countries and contexts. So that was a strikingly low number. And again, this is an area where the Biden administration said, we will do this differently. In May of 2021, during the first year in office, the Biden administration revised that fiscal year target upward, but not hugely, and in ways that I think led to disappointment by some people who had supported him in the campaign, raising it to 62,000 or 62,500. So it came up, but it was still historically quite low. And by the end of the fiscal year, fewer than 12,000 people had actually been admitted as refugees. So part of the story of the Trump administration was systemically sort of dismantling all of the refugee resettlement programs that had previously been in place, which meant that even in ramping up the numbers for refugees, having the bureaucratic ability to actually bring people in and resettle them was significantly impeded for the Biden administration. And the Biden administration also pivoted to concern for Afghanis who were fleeing the country in the wake of the U.S. abandonment of its role in Afghanistan as well. So all of that kind of contributed to the low number of refugee admissions here. The cap in fiscal year 2022 has been set at 125,000. So we're back up to what kind of more historically normal and maybe even slightly higher than some of the numbers we'd seen in recent years. So it looks like there is an effort to sort of try to regain ground on overseas refugees admissions. Those numbers are still tiny when you think about the sort of overall number of refugee flows. And when you think about the numbers of refugees that much smaller nations, for example, like Poland, in the wake of the crisis in Ukraine, have taken on systematically. For asylum, then so those are overseas refugees, but then there are also people who are coming to the border or are present in the country who are also saying that they meet the statutory definition of a refugee. That would be in keeping with the image that I'm showing here, people coming to claim asylum. And there we saw under the Trump administration, Attorney General Sessions and Attorney General Barr using their power over the immigration court structure to move the law in ways that really limited the ability of large groups of people to seek asylum, largely by defining the social group protections of asylum law much more narrowly. And we have seen Attorney General Garland vacating some of these decisions and trying to re-expand in some dimensions the definition of what it means to be a legitimate asylum seeker. But that's a place where the law still has not fully moved back to where it was prior to the beginning of the Trump administration. So that's kind of at the border where I think we see both continuities and shifts. On the interior enforcement story, we see shifts and not always fully visible and not complete shifts, but we do see some shifts. President Trump obviously said that he was deeply committed to deporting everybody who was present without authorization or anybody who was deportable, which would include longtime lawful permanent residents who had committed removable offenses, et cetera. So, literally tens of millions of people potentially removable under the immigration law. And President Trump's campaign rhetoric was that he was committed to removing them all. What was interesting to see when you look at the statistics of who was actually removed is that those numbers, the numbers of the people that were removed from the interior of the United States, were issued removal orders over the course of the Trump administration, never hit the historic high numbers that were hit under the Obama administration and peak Obama administration years, like from 2010 to 2015, you actually see higher numbers of people being removed from the interior of the United States under Obama than you see at any point during the Trump presidency. So we might ask, well, what accounts for this? And some of this is about sort of bureaucratic competencies, right, and getting things done and who has the capacity to do that. But some of this is also a story of state and local resistance, right? Which, although Obama was deporting a lot of people, you didn't have quite as much widespread resistance to President Obama's immigration initiatives on the parts of states and localities. You started to see growing resistance to some of the aggressive interior enforcement approaches that the Obama administration took in places like California as we got to the second Obama term. But before that kind of opposition was mobilized, Obama had a lot of latitude to lean on states and localities to assist in identifying individuals potentially subject to removal and using that as a means of enhancing federal capacity to remove people. And the Obama administration did that in the period from 2010 to 2015. And then began, I think, to use a much more discretion and caution in terms of how it was leaning on states and localities. President Trump, I think, really wanted to take advantage of the full possibilities of using state and local law enforcement to serve, to supplement the federal immigration system. But he met with a lot of resistance, I think in part because his rhetoric was off-putting enough that many jurisdictions that had not overtly resisted during the Obama administration were much more overt about their resistance during the Trump administration. So this leads to the things that some people refer to as sanctuary policies. They're not truly sanctuaries in the sense that the federal government still has the capacity to remove people, but they do put limitations on the extent to which state and local actors can cooperate with federal immigration enforcement officials. And this had a real dampening effect on President Trump's, the ability of President Trump's immigration enforcement teams to remove people. If you're not getting cooperation from state and local actors, that severs off a big part of the pipeline that is feeding removals. And so you didn't see the big jump in removals that you might have expected to see between Obama and Trump. You really don't see that at all, notwithstanding rhetorical differences, but you still see lots of people being deported under President Trump, just as you saw lots of people being deported under Obama and under Bush before Obama, right? So there's a story of continuity there. We do see, I think, some reduction of that under Biden, at least in early numbers, and it's early to say, and the data is difficult. But it looks like removals are substantial, interior removals are down substantially from Trump administration highs. So it looks like the administration is administratively closing more cases, removing fewer people overall, perhaps also confronting some of the non-cooperation laws that were put in place when Trump was president. And overall, the removal numbers are coming down, but they're still high. And the Biden administration has said that its plan is to focus on individuals with criminal convictions. Given what we know about criminal legal systems nationwide, this has a racial impact in terms of who is prioritized for removal and who is not. And it's not done in terms of people's ties to the country, which might be another, as one scholar has proposed, might be another better way of thinking about how to remove. The Biden administration has restored some practices like administrative closure that allow judges to not remove people even if they fit the definition of removal that the Trump administration had discouraged and tried to foreclose. And the Biden administration has said that it will not do things like engage in spectacular workplace raids where they descend en masse to a poultry processing plant or a slaughterhouse and round up people in a sort of dragnet style situation and then try to sort out who has authorization to work. So those are changes that we see on the interior enforcement scene, and they're substantial. Immigration detention continues, I should say. It grew, it's grown substantially over time, really since the mid 90s through the present under every administration. Interestingly, because of COVID, slowdowns in processing, COVID concerns, immigration actually dipped at the end of the Trump administration and is rebounding now under the Biden administration. the Biden administration has said that they are, they committed to ending the practice of long-term family detention. They've closed a couple of detention facilities that they found particularly problematic, but there does not seem to be any change in a commitment to maintaining a fairly expensive, elaborate, and extensive system of immigration detention, and those beds are increasingly full. So that's in place where we see continuity across administrations with some changes as well. And then what about laws that protect certain groups of people? This is where I will almost wrap up. I wanted to talk about two. One is temporary protected status, and the other is deferred action for childhood arrivals. So temporary protected status is a statutorily authorized designation by the president that allows designated foreign nationals displaced by armed conflict, environmental disasters, other extraordinary conditions to stay and to work lawfully in the United States for a designated period of time, subject to renewal by the executive branch. So you get 18 months, and then if the executive branch renews TPS for that class of people, then they can stay another 18 months. Everyone's living their life in sort of temporary increments. There is no sort of long-term path to a more permanent form of legalization via TPS, but it protects people in that moment. And some of those TPS designations have been reauthorized in multiple years, meaning that some people have been in the United States on TPS designations for more than 2 decades, right? So you can be quite a long-term resident with temporary protected status. The Trump administration sought to revoke TPS for nearly 300,000 residents, including some who had had quite long-term protection under TPS from El Salvador, Haiti, Nicaragua, and Sudan. That was litigated. Challenging parties pointed to the president's history of racist statements, racist as against the very people who would be targeted by this TPS revocation. And again, to procedural flaws in the revocation process. And successfully, that litigation was actually successful in sort of freezing the designations in place. And President Biden has extended TPS for these individuals and for some others, including Afghanis and Ukrainians, sort of restoring TPS as a form of protection for people who don't fit perhaps the refugee definition or don't have another mechanism for seeking protection. TPS is complicated and controversial in part because it does not offer any kind of a pathway to a long-term residence or status. It feels sort of anti-democratic and illiberal to have people who are in a perpetually temporary state with no ability to be sort of more formally included in the political process. And that's something we can talk about as well in the Q&A period, but that's where matters stand with that. And the final issue that I wanted to talk about here to make sure to leave plenty of time for questions or diversions or going down other roads entirely was DACA, or Deferred Action for Childhood Arrivals. So DACA is almost 10 years old now. So you might remember that this was something that was announced by President Obama, issued by a memo from Janet Napolitano, then Secretary of the Department of Homeland Security, that provided qualifying individuals who had been brought to the United States, had come to the United States when they were children, and who met certain criteria to be able to apply for work authorization and protection from removal. So like temporary protected status, it is a temporary designation that does allow for work authorization, but that has no inherent path to any more stable status. And like temporary protected status, it requires individuals to renew their request every 2 years. So people are sort of, again, living their life in 2-year increments. The hope, I think, always was that Congress would act to provide more lasting forms of protection for individuals who largely think about the United States as their primary home, and who sort of culturally and educationally have all of their deep roots in the United States, but that hasn't happened. So we are here 10 years later, and President Trump actually tried to rescind the DACA program. And cited to some lower court decisions that had raised questions about its legality and threats by state governments to sue if the president did not himself rescind it. So President Trump, through Secretary of Homeland Security Dukes announced the decision to rescind deferred action, and that was that brought out some litigators, right? That was challenged in court under both the Administrative Procedures Act for having been a deficient a rescission process, and also under the Equal Protection Clause for being a discriminatory policy on the part of the Trump administration. The Supreme Court, in a 5-4 vote, found the rescission to be unconstitutional, found the rescission to be a violation of the Administrative Procedures Act, did not find that there was an equal protection violation. And so the court said you need to have a better process by which you rescind DACA. The Biden administration, Biden obviously campaigned on a platform that supported DACA and its continuation. The Biden administration has initiated formal rulemaking to formalize regulations around DACA. Those are controversial, and we can talk about that if people wanted to. But we also still see rumblings in federal courts around DACA. So in July of 2021, Federal District Court Judge Andrew Hanen, who has been the site where a lot of the DACA litigation has taken place, concluded that DACA was improperly issued as a procedural manner and was in conflict with the immigration law as a substantive matter and is therefore unlawful. So although the program continues, that is, people with DACA continue to be able to apply for renewals for DACA, Hanen has enjoined any new people from entering the program. And so one implication that has as someone who sits in a university is it means that we will have a lot of incoming students who have lived in the United States for the vast majority of their life and have been admitted to college who are going to be out of status, which has always been true to some extent, but DACA really mitigated that sort of the large numbers of people coming to campus out of status. And I think that's something that we will be seeing again because the program is frozen in place and Congress seems incapable of doing anything to remedy this situation. So that's where we are with DACA. So I'll stop there. There are lots of other things we could talk about, obviously, many different issues relating to visa issuance, to bans and trying to recover from bans, changes in refugee flows. And I'm happy to talk about any of this to the extent that I can. And if I can't, I'm happy to own to my ignorance. And so I look forward to the conversation. I think I'm going to stop sharing screen because you don't need that anymore. And I will look at the Q&A and see what we have there. So it looks like, okay, so I got one just thank you for having an immigration law course, class of 99. And I want to say that, you know, I was really lucky when I went on the job market wanting to teach. And wanting to teach specifically immigration law. I was interested in constitutional law, criminal law and procedure, and immigration law, and the places where those things intersect. And many faculty at the time I was going on the market in the very early 2000s didn't have full-time faculty that were dedicated to or studying immigration law issues. It was seen as peripheral, it was seen as minor, it was seen as, you know, something that you would occasionally, if you really needed to, bring an adjunct in to teach if there was student demand. But I was going on the job market shortly after September 11th, and we saw major upheavals in terms of the structure of the Department of Homeland Security, in terms of the structure and operations of immigration enforcement. And those changes, I think, had caused a lot of faculty in a lot of places to rethink this sort of pigeonholing of immigration law, and instead prompted them to think about sort of how this question intersects with other important questions of constitutional law, national security, race, and identity. And so that happened to be the time I was going on the job market, and that was a lucky thing. And the University of California at Davis hired me to do this and to teach this, and I've been going ever since. The next question is I believe that Biden planned to tackle some of the flaws in lawful immigration as well. The state of the plan to allow H-4 visa holders to get work permits, even if the H-1B visa holders does not pursue a green card. What's the state of the plan? And I don't honestly know what the state of play is on that, but for people who are not in the weeds on immigration law, when we're talking about H4s, we're talking about people who are not the primary holder of the work visa, but are coming sort of attached to a primary holder of the work visa. And there have been, under various administration regulations, that allow those individuals to work as well. It's an area where the statute is sort of spacious, and administrations have filled that space by allowing for work authorization. That was one area where, again, if we're thinking about sort of channels to legal immigration and encouraging legal immigration, that was one area where the Trump administration took a position that was kind of antithetical to that mission by clamping down on H4 workers. And I think it was one of the sort of, presumably one of the Biden, one of the expectations was that the Biden administration would work quickly to ensure wider access to work authorization for those individuals. And I don't know what the status of it is, but I think the question sort of speaks to the fact that there were literally thousands of subtle regulatory and rulemaking and policy changes that the Trump administration did in spaces that affected immigration broadly, access to visas, access to work authorization, processes by which those things were accessed, that had a significant effect on thousands of people, and that are difficult to reverse and to reboot, and that take time and process. And so it's not a fast policy swing sometimes from one administration to the other, unless the administration is committed to, or so committed to the agenda that they're willing to break rules and break things. And that's really what we saw with the Trump administration, right? We're going to enact a travel ban. We don't know if it's constitutional, but we're rolling it out on, early days of our administration. So that sort of willingness to go all in full throttle, even if it seems unlawful or unconstitutional, was an unusual characteristic of the Trump administration. And because immigration law is in many ways a space where there is not a lot of constitutional regulation and protection, he actually had a lot of room to work there. And he did. And so I think working backward from there is a process if you are more sort of rule bound than the former president's administration might have been. Mike Spillner says, regarding the Remain in Mexico, did the Biden administration have to immediately reinstate MPP, or were there opportunities to interpret the order in a way that could have stopped MPP anyway? It seems like the Biden administration didn't fight that hard once that order came out. I think I share your sort of perception of what happened there. So the order obviously can't say reinstate MPP, right? They can't unilaterally, the judge can't unilaterally impose an order requiring MPP to be reinstated, because MPP by definition requires the acquiescence and cooperation of the Mexican government. You can't have MPP if Mexico is not a part of this conversation. It's quintessentially a foreign affairs issue, which is why the decision is so interesting in many ways. Foreign affairs is typically a space where the judiciary defers to executive choices and doesn't second guess. And yet this is a place where the federal district court judge in Texas was quite comfortable saying, go and negotiate and do what you can. So that was the nature of the order. There had to be good faith negotiations for the restart of MPP. And I think the Biden administration really took that to heart and engaged in good faith negotiations. I think more foot dragging on this would have been possible. And I also think one of the things that was interesting was it's not just that they didn't foot drag, it's that they really sought to sort of expand and formalize various elements of MPP through this negotiation process that I think really left some people with a bad taste in their mouth. So not only are you not sort of fighting it on every possible front or looking for every creative way in which you might fight this with legal tools, but you're also sort of bending over backward to comply in ways that maybe are even broader and more capacious than required. So I guess I share your sense that it wasn't perhaps as full-throated rejection of the principles of the district court judge's order as we might have expected to see, and would have probably seen if different Democratic candidates had been taking the lead there. So now we do see the Biden administration sort of taking the sort of expected course of contesting this. If you look at the Solicitor General's brief, really citing to the fact that the statute doesn't require it and nobody's ever interpreted it that way, and that the president should get deference on these questions of foreign policy and negotiation, and none of that happened in this case. So I think that, they're pursuing the expected arguments against it, but it is somewhat striking that they didn't sort of view this as a place to sort of use legal imagination to think about other ways to minimize the footprint of MPP or otherwise minimize its harms. Josie Gonzalez says, is there any likelihood that legislation will pass in this administration comparable to IRCA, the Immigration Reform and Control Act of 1986? I have stopped answering this question. In part because I was actually hopeful. There have been various points in time when I've been hopeful. I was hopeful in in 2000 that there might be some sort of a compromise, if nothing else, sort of bilateral movement between the US and Mexico in that moment. Then September 11th happened, and that was off the table completely. There was not only no reform in immigration law, but there was really a move backward in terms of how migrants are treated in the United States, and no action in terms of legalization. We saw energy again around 2006. That went nowhere. We saw energy again in 2013 when we even got passage by one chamber of a comprehensive immigration reform bill. And I really thought that it was going to happen then. I thought that so much that I, along with others, applied for a grant to do research on how that program would roll out, right? Identifying organizations, seeing how people would be screened, seeing how, that was my level of optimism 9 years ago. And that that was not a well-placed optimism. And so now here we are. I do think, the tenuous place of DACA recipients alongside some increasing concerns about labor shortages in certain sectors that have been decimated in part by immigration policies, frankly, those might, theoretically could generate some momentum in favor of legislation. It should generate momentum in favor of at least some sort of limited form of legalization for some subset of people who are worthy of legalization. But I'm pessimistic. I don't think that that most Republicans think they have anything to gain by coming to the table on that sort of legislation, and the Democrats don't have the votes to do it alone, and some of them are sort of squishy anyway on some of these issues. So what's weird about this is we have things like deferred action, and for that category of people, there's widespread popular support for just providing what should be just instant citizenship, but will inevitably be some sort of long and torturous pathway to citizenship. There's pretty broad consensus nationally that should just be done. It's not controversial, and yet because this is such a high valence issue and an issue of such high salience, particularly for Republican voters, it is something that I think Republican politicians are nervous about touching. So I would love to see it, and maybe with more mass mobilization and more pressure from people like me or you, calling and putting pressure on legislators, maybe something can happen. But it's surprising how long Congress has been willing to do nothing on this issue in the face of pressing need, and I don't see anything that's pushing in another direction. I really hope I'm wrong. I would love to be. I hope we record this and that someday somebody laughs at me for saying this. That would be a beautiful thing, and it would make me very happy. But I'm feeling sort of pessimistic today. I hear there's been a push to make immigration courts more independent. Can you say a little bit about that? Yeah, so immigration courts, for those who practice in this area, immigration courts sit within the Department of Justice, and they have throughout time, and particularly in the past couple of decades, been really subject to a lot of political control and pressure. This takes a lot of different forms. It takes the form of dismissals of Board of Immigration Appeals judges when their rulings are to the contrary of the preference of the administration. We saw that under President Bush when the BIA was radically shrunk, and all of the judges who were removed from the Board of Immigration Appeals were the more pro-immigrant judges. So it was pretty clearly ideologically designed. We've seen sort of controversy, certainly in the Bush administration, over the selection of immigration judges and the sort of political litmus test that immigration judges seem to go through. And then there's the issue of sort of control on the part of the Department of Justice over the law in this area. So I mentioned Jeff Sessions and Attorney General Barr and Attorney General Garland as writing cases in this area, because they do. If they disagree with a Board of Immigration Appeals president, they can call a case to themselves as Attorney General and rewrite it. So these are not independent courts in any way. They are very much influenced by whoever is in the White House, both in terms of pressure to manage their caseloads and their dockets, pressure in terms of outcomes, and who gets promoted and who doesn't, and who gets disciplined, and also direct intervention by the Attorney General in sort of defining the law. So in all the ways that matter, immigration courts really do lack independence. And so there have been a number of proposals, including one that I think is currently gaining traction, to increase the independence of these courts and move them out of the Department of Justice, to give them some degree of insulation from the political process, right? Maybe it's sort of Article 1 courts, but this is not Article 1 courts, but not sort of something that looks more like Article 3 courts, right? Something that looks more independent. I don't know what the if I'm playing the odds, I don't know how likely that is, because again, the payoff isn't there for a lot of politicians, even though this is clearly a problematic state of affairs. The kind of the political pressure to do something about it may not be strong enough. What should the Biden administration be doing to prepare for the rescission of Title 42 and the potential end of MPP? So that's a great question. And I think, the Biden administration is basically talking about ending Title 42. Like it's going to happen, right? And part of the reason they've been slow is because they are nervous about what that will look like. But I think, what's interesting is it's people have talked about the fact that this will generate, this unprecedented flow of people, including people who have been sort of pent up at the border because of these orders. And that, our system will be overwhelmed because it's unusual or unprecedented. And that's where we just need to take a step back and sort of recognize that none of this is unprecedented and all of it is predictable, right? People are moving for obvious reasons. The incentives to move are not changing. The reasons that they go to particular places are quite predictable. People who study migration are not surprised by any of this. And the fact that we are continually surprised by this and can then, because we're surprised by it, talk about it as a crisis, speaks to the lack of seriousness with which we study the phenomenon of migration. Right, and instead treat it as a political hot potato. So if we know that there will be large numbers of people who are seeking to migrate from certain places and that they're going to come to certain places, then it makes sense to have procedures in place and to invest in procedures in places that will allow them to access, the legitimate process to which they're due under the statute. We then have to mobilize the resources to do that. Resources in terms of adjudicators, resources in terms of agents, right? And also we have to get comfortable with the idea that unless you want massive detention camps all along the southern border, then you have to get used to the idea that unless your processing is instantaneous, there needs to be the ability for people to be paroled into the country to have their cases heard, and there should be mechanisms and structures to do this. Now, we could get rid of all of this with a much more open bordered system that doesn't require quite so many jumping through of so many hoops, but that's not on the horizon. And since that's not on the horizon, then it does seem that like that you need to address the problem as one that is not a crisis and not unprecedented and not unexpected, but as utterly predictable and knowable, and to which, if you're serious about affording rights and allowing people to make claims, you will dedicate the resources that allow for that to happen. I don't see Congress doing that, which is why the Biden administration is then going to be put in a situation of triaging resources to deal with what will be spun as a crisis. And that will, we'll all watch this play out. We can predict exactly how this will happen. But it's not a fault. We can't fault the administration for this when the institution that controls the purse strings hasn't done anything to allow for a flow of resources to meet a challenge that we know is coming. Do I see Texas being allowed to continue with its own efforts to have its own border policies and restrictions on immigration? I have only 1 minute. Texas is my home state, so I have lots of thoughts on that. But yes, I think that I just want to say Texas really has decided that it can engage in its own sort of border policing. They are essentially arresting and charging with state crimes individuals whose offense really, the offense that they're really concerned about is unauthorized migration, and that has been a federal prerogative. But there has been some effort on the part of the Biden administration to intervene in what Texas is doing there and to challenge what Texas has been doing in that space. But I think we're seeing a lot greater tolerance for these kinds of restriction of state moves in the immigration space, certainly in many federal courts. So again, I don't know how to game this out. It does look patently unlawful under existing preemption doctrine. But the fact that something's patently unlawful under existing law doesn't answer the question of whether or not it will be allowed to persist. So I know we have 5 minutes left and I'm supposed to stop there, so I will stop.
Thank you so much, Professor Chacón. I think you actually managed to hit every question that was posted in the Q&A. So thank you so much. This was, I practice in intellectual property. This is nothing, this is nothing that I deal with professionally, and certainly, but certainly on a headline level, this is such an important area. So thank you for giving me the opportunity and giving all of us the opportunity to think about it for an hour. So in the chat, there is a CLE form again posted. Let's see, what else am I supposed to do in my closing remarks? We have another faculty talk coming up next time, another virtual faculty talk coming up, next time hosted by the Los Angeles Alumni Chapter, and that's May 5th at noon. And that's going to be Professor Andrea Roth talking on artificial intelligence, algorithms, and the courts. So I'm going to spend part of my Cinco de Mayo at that, I'm sure. And you can register for that on the alumni events page on the website. And that was one of the links earlier on, but maybe we can get that posted again. Everybody, you will get your CLE certifications if you fill out that form by the beginning of April. And thank you so much, Professor Chacón. This is really interesting. The Silicon Valley chapter and the rest of the alumni also, thank you very much.
Well, thank you for having me. It was a lot of fun. I see I didn't answer your question, but maybe I'll take that offline. And definitely don't miss Professor Roth. She's much funnier than I am, and I'm sure the presentation is going to be delightful.
All right. Well, thank you, everyone. Have a good afternoon. And we will see you at the next thing.